is that in a time, as everybody knows, when the middle class of this country is struggling, when people are working longer hours for lower wages, when half of our people live paycheck to paycheck, when people can't afford health care, they can't afford child care, finding it hard to fill up their gas tanks. All over this country, there is a growing movement on the part of workers to try to organize and form unions, because they understand that if you have a union, you're going to have better wages, better working conditions, and better benefits. And yet, at exactly the same time that working people are standing up and fighting back and are interested in joining unions, well, you're also seeing that there are hundreds of corporations in the United States, including some of the very largest, that receive federal contracts that amount to many billions of dollars. They receive huge subsidies, they receive special tax breaks, and they receive all kinds of corporate welfare, despite the fact that these very same companies are engaged in widespread illegal behavior, including massive violations of labor law. And the question that we're asking today is a very simple one. Should federal taxpayer dollars go to companies that violate labor law and illegally prevent workers from exercising their constitutional rights to join a union? While corporations engaging in illegal activity against union organizing is not new, and it is widespread, this morning we're going to focus on one company, Amazon, who, as we speak, right at this moment, is engaged in massive, well-funded anti-union activity. As I think all of us know, just last month, Amazon workers in Staten Island voted to form the first union at Amazon, and Amazon is one of the largest employers in the country, almost 1 million workers. And this followed a union organizing attempt at an Amazon warehouse in Bessemer, Alabama. And organizing a union in Bessemer, Alabama ain't easy, and we thank those workers who are here with us today for joining us from Bessemer. From the very beginning of the union organizing efforts until today, Amazon has done everything possible, legal and illegal, to defeat union organizing efforts. The National Labor Relations Board, NLRB, found that Amazon's flagrant disregard of the law infringed on workers' legal rights to a free and fair union election in Bessemer, Alabama, ruling that Amazon's behavior was, quote, dangerous and improper. That is the National Labor Relations Board. To date, there are currently 59 unfair labor cases against Amazon pending at the NLRB. Amazon is currently being sued by the NLRB to reinstate a worker who was illegally fired for organizing a union. Several current and former employees have alleged that Amazon has engaged in illegal harassment and discrimination based on race, gender, and sexual orientation. And that's not all. Amazon has already been penalized more than $75 million for breaking federal discrimination and labor laws. Amazon misclassifies delivery drivers as independent contractors rather than employees to evade tax, wage, and benefit responsibilities. Amazon's inadequate workplace safety policies also pose grave risks to workers, and I hope we'll be able to discuss that a little bit today. If you can believe it, and Mr. Graham, Senator Graham, this is really rather an astounding fact. According to a New York Times investigation, Amazon has a 150% turnover rate, 150%. Workers come into these warehouses, they are worked as hard as humanly possible, and then they leave, often crushed. And a whole set of new workers then comes in to replace them. Is that really the kind of business model that we should be rewarding with massive federal contracts? Further, in some locations, Amazon's workplace injury rates are more than 2.5 times the industry average, and that may be understating the case because not all injuries are reported. Last December, 6 Amazon workers died after they were required to continue working during unsafe weather conditions in a warehouse that did not have appropriate safety facilities or policies. It is abundantly clear that time and time again, Amazon has engaged in illegal anti-union activity. Further, Amazon cannot even come to grips with the reality that the workers in Staten Island won their union election fair and square. In order to stall the process out, their lawyers have appealed that decision, result to the NLRB. Their strategy is obvious, and I look forward to discussing that with our panelists. They're going to stall and stall and stall. In every way possible, they are refusing to negotiate a first fair contract with the Amazon labor union. So today, my question to Jeff Bezos, who is the second wealthiest person in our country, worth about $150 billion, is a pretty simple one. And it really speaks to the kind of corporate greed and excessive greed that we are seeing right now in America. Mr. Bezos, you have enough money to buy a $500 million yacht. You got enough money to buy a $175 million estate in Beverly Hills and a $23 million mansion right here in D.C. Given all of your wealth, how much do you need? Why are you doing everything in your power, including breaking the law, to deny Amazon workers the right to join a union so that they can negotiate for better wages, better working conditions, and better benefits? How much do you need? And the answer is not complicated. What Mr. Bezos understands and what he is fighting is the reality that union workers in America earn about 20% more than non-union workers on average. Mr. Bezos understands that 79% of union workers have a defined benefit pension plan compared to just 17% of non-union workers. Mr. Bezos understands that union workers are half as likely to be victims of health and safety violations compared to non-union workers. And that is why Mr. Bezos and Amazon have spent over $4 million last year on union-busting consultants and lawyers. That is why Amazon is forcing workers to attend captive anti-union meetings. Take a group of workers that don't have any choice, put them in a room, and you brainwash them with anti-union propaganda. And that is why Amazon has fired workers simply because they are pro-union. Well, my message to Mr. Bezos is this, and that is that all over this country, people are standing up and fighting back for economic justice. They are tired of seeing billionaires get much richer while they can't afford health care or child care, or in fact, in some cases, the ability to feed their families. So we say to Mr. Bezos, stop the intimidation, stop the harassment, stop the coercion, stop the illegal behavior. Start treating your workers with the respect and dignity they deserve. They are the people who made you your billions. Give your workers a seat at the bargaining table. Give all of your workers the freedom to join in a union if that is what they choose to do. During the presidential campaign, then-candidate Joe Biden promised, and I quote, to institute a multi-year federal debarment for all employers who illegally oppose unions, end of quote, and to, quote, ensure federal contracts only go to employers who sign neutrality agreements committing not to run anti-union campaigns, end of quote. That was what candidate Joe Biden said. In my view, that campaign promise was precisely right, and today I am reviewing my request to President Biden to fulfill that promise. That's what you said on the campaign trail. Let's do it. President Biden, more than any other president in my lifetime, has talked over and over again about being pro-union. And I appreciate the president's words, and I believe him to be sincere. he is pro-union. In my view, however, the time for talk is over. The time for action is now. Taxpayer dollars should not go to companies like Amazon who repeatedly break the law, and we're talking about billions and billions of dollars in contracts. No government, not the federal government, not the state government, and not any city government should be handing out corporate welfare to union busters and labor law violators. Senator Graham.
Thank you, Mr. Chairman. I really enjoyed working with you, but wow. This committee is taking a very dangerous turn under your leadership, to be honest with you. You're singling out a single company because of your political agenda to socialize this country. Every time I turn around, you're having a hearing about anybody that makes money is bad. The government needs to grow beyond our ability to pay for it. And we're going to have an election on your ideas here soon, and I can't wait. As to the process, there's a process in this country. If you feel like the law has been violated in your efforts to unionize the workforce, you can file a complaint. People will have a hearing. There's a process to debar companies who engage in illegal behavior. There is a process. This is a political process here. This is an effort to get an outcome you want, using the United States Senate as your vehicle. This is very dangerous. You can have oversight hearings all you like, but you've determined Amazon is a piece of crap company. That's your political bias. They're subject to the laws of the United States. They shouldn't be subject to this. If we get the committee back, we're not going to do this. We're going to talk about how to save Social Security, keep Medicare from becoming insolvent, how to change the structural problems of our debt. I'll talk to you about climate change. What happens if you electrify all the vehicles in the country? What does that mean for power producers? I'd like to work with unions. Got an uncle who was a vice president of a union, paper mill union, to bring jobs back into America. I'd like to work with companies, unions, and the private sector to become energy independent again. So I'm not here to demagogue the union process in this country. I'm here to say that if you're a business, you can have a say too about your workforce. The idea that you can only get a government contract if you promise to be neutral is ridiculous. Boeing is in South Carolina making the 787. There's been efforts to unionize Boeing. They lose. The people in that plant will make that decision. The idea that Boeing can't argue the merits of a right-to-work environment for their business is ridiculous, and I think patently illegal. This is a heavy-handed approach, the most radical agenda in my lifetime, and it should be carried out at the ballot box, and it will be. If we take this body back, this demonization of individual companies that are subject to the law will cease. Thank you.
Okay, now we are going to hear from our panelists, and I thank them very much for being here. We have 5 panelists: Mr. Christian Smalls, Mr. Sean O'Brien, Mr. Greg Leroy, Ms. Rachel Gressler, Mr. Glenn Spencer. Let me begin with Mr. Christian Smalls. Mr. Smalls is the president and founder of the Amazon Labor Union. Mr. Smalls has been organizing labor actions at an Amazon warehouse in Staten Island known as JFK 8 since 2020. The JFK 8 warehouse voted in favor of unionizing with representation of the American Labor Union on April 1st. Mr. Smalls, thanks very much for being with us.
Thank you for having me. Well, first off, I want to address Mr. Graham. First off, it sounded like you was talking about more of the companies and the businesses in your speech, but you forgot that the people are the ones who make these companies operate. And if we're not protected, and if the process for when we hold these companies accountable is not working for us, then that's the reason why we're here today. That's the reason why I'm here to represent the workers who make these companies go. And I think that it's in your best interest to realize that it's not a left or a right thing. It's not a Democrat or a Republican thing. It's a workers thing. It's a workers issue. And we're the ones that are suffering in the corporations that you're talking about, in the businesses that you're talking about, in the warehouses that you're talking about. So that's the reason why I think I was invited today to speak on that behalf. And you should listen, because we do represent your constituents as well. So just take that into consideration, that the people are the ones that make these corporations go. It's not the other way around. So as the current interim president of the Amazon Labor Union, who represent 8,300 workers in Staten Island, an independent worker-led union that won their election on April 1st, I'm going to tell you this. We organized for over a year. And throughout the course of that year, Amazon spent millions of dollars, as you mentioned, Senator Sanders. Myself, including a few other organizers, was arrested outside for organizing, arrested for delivering food to their coworkers. I wanted to reiterate that as well. You know, the type of things that Amazon do, breaking the law, intimidation, these are real things that traumatize workers in this country. You know, thousands of workers across this country who are in the process of organizing, who have the desire to organize in the United States. We want to feel that we have protections. We want to feel that the government is allowing us to use our constitutional rights to organize. The notion that people in the united in this democracy will outmatch tyranny is the oldest American ideal. There's clearly defined legal process to do this, and workers like us have the rights protected by the First Amendment and the National Labor Relations Act. However, despite all of this, our victory in Staten Island was lauded as newsworthy and inspirational for the thousands of workers across the country, hundreds of thousands of workers. And even though we may have won, we did everything right, pressuring Amazon to recognize our victory and comply with our legal obligation to meet us at the bargaining table. But Amazon is refusing to do so. As you mentioned, they're going to stall. They filed 25 objections, and they got the NLRB to move the hearing to a whole nother location. To me, it just sounds like the corporations have the control, and they control whatever they want. They break the law, they get away with it. They know that already, that breaking the law during these election campaigns won't be resolved during the election campaigns. So they purposely continue to break the law. For example, we filed over 40 ULPs in 11 months. Most of them, or quite a few of them, got merit for further action. Some of them even got injunctions. For example, Gerald Bryson was fired 2 years ago. Finally, 2 years later, over 2 years later, there's a 10J in motion for his reinstatement. Another prime example, Daquan Smith was fired by the company for organizing. He's still out of a job. He's living in a shelter right now. We raised money through GoFundMe. These are just a few examples, including myself, who's been out of a job for the last 2 years. I want to just end off by saying this. We need to pass the PRO Act so that workers are protected and workers are encouraged to organize. And if that don't work, I'm going to let you know right now that on behalf of the Amazon Labor Union and the hundreds of thousands of workers across this country, that we will continue to organize. And once again, I want to remind you that this is not a left or right thing. This is a working class issue. And the workers at the bottom are the ones who make these corporations go. Thank you.
Mr. Smalls, thank you very much. Our next panelist is Sean O'Brien. Mr. O'Brien is a fourth-generation Teamster and the General President of the International Brotherhood of Teamsters, one of the largest unions in this country with some 1.4 million members. Mr. O'Brien was the youngest person elected as President of Teamsters Local Union 25, a position for which he was reelected 6 times. He was sworn as the 11th General President of the Teamsters this March. Mr. O'Brien, thanks so much for being with us.
Thank you very much. Good morning, Mr. Chairman and members of the committee. My name is Sean O'Brien. I'm the General President of the International Brotherhood of Teamsters. Thank you for the opportunity to appear before you today to discuss Amazon, its labor and business practices, and its relationship with the federal government. To put it plainly, it is wrong for our government to be giving taxpayer dollars in the form of federal contracts to companies like Amazon. You are rewarding employers who repeatedly, knowingly, and purposely violate federal labor laws, drive down wages and standards in core Teamster industries, and create dangerous working conditions. To be clear, President Joe Biden is the most pro-union president of our lifetime, and the Teamsters Union applauds his administration's actions on issues of great concern to working families. We proudly support President Biden's executive orders on pay equity and $15 an hour minimum wage requirements for federal contractors. And the recommendation for federal procurement included in the White House Task Force on Worker Organizing and Empowerment will support and encourage responsible, high-road employers. But as Chairman Sanders has said, we have the power to completely stop companies that break labor law from receiving federal contracts, so why are we not doing it? As we already know, Amazon is a habitual lawbreaker. The company was found guilty last year of illegally firing 2 workers after they advocated on behalf of their co-workers at an Amazon warehouse. Amazon broke labor law in Alabama when workers tried to organize, forcing their election to be rerun this year. In December, the NLRB cited Amazon for illegally threatening, surveilling, and interrogating workers who were trying to start a union at its Staten Island facility. These kinds of actions make something very clear. When workers try to organize, Amazon breaks the law. When workers raise their voices, Amazon does whatever it takes to shut them up. Because Amazon is terrified of the power workers have when they act collectively. Sadly, while Amazon acts with impunity to break the law, our government recently saw fit to award the company a $10 billion federal contract for cloud computing services. While our government was spending taxpayer dollars on Amazon's web services, the company reportedly spent $20,000 per week on union-busting consultants in Staten Island alone. What's more alarming is we know that these numbers barely scratch the surface of what Amazon spends to prevent workers from having any voice whatsoever on the job. Americans have the fundamental right to join a union together and bargain collectively over the terms of their employment. The federal government, under the National Labor Relations Act, has a mandate to encourage worker organizing and collective bargaining and to promote equality of bargaining power between employers and employees, as President Biden's executive order on worker organizing and empowerment boldly states. But our government ignores that mandate with every dollar that it puts into the pockets of Jeff Bezos and his organized crime syndicate known as Amazon. Why are elected officials giving taxpayer money to a company that is willing to use any available means, illegal or not illegal, to deny workers their federally protected rights? Why are we supporting the growth of a company that is destroying good middle-class jobs, creating unsafe working conditions, and assuming no responsibility for much of its workforce? As a Teamster, I've faced countless union-busting companies. As a proud Bostonian from a tough neighborhood, I've confronted my fair share of schoolyard bullies too. Let me tell you, you don't take a beating from a bully, then fill his pockets with money and expect fewer beatings. Amazon has been beating up on American workers for too long, and our government has been letting them do it, and it needs to stop. Amazon relies on an exploitive business model that's simply brutal for workers. The company's punishing pace of work results in worker industry rates that are nearly twice as high as that of all other non-Amazon warehouse facilities. Amazon employees are seriously injured at rates that are nearly 80% higher than the rest of the entire warehouse industry. Amazon accounts for all warehouse worker injuries, yet the company only employs a third of all workers nationwide. Why is our government rewarding this behavior? Why aren't we doing more to actually protect American families? As the General President of the Teamsters Union, a union that represents more than 1.2 million working people, I've been traveling the country a lot this year, spending time with workers face to face. And I'll tell you this, working people of all parties are losing faith in our government. It feels like big business is the only thing our government cares about. What happened to we the people? Billionaires pay little to no taxes, and then they are handed billions of more by our government after they break the law. When our government turns a blind eye to Amazon's lethal and illegal practices, it feels like the system is rigged against everyone but the rich and powerful. But working people aren't stupid. We see what's going on here. It's long past time for the pendulum to swing back to the side of hardworking families in this country. To this committee and to the entire federal government, do your duty to protect American workers. We are watching, we are listening, and we are voting. Tell Amazon that enough is enough, and then show them you mean business. Don't give this company or any employer another penny until the labor laws of this land are truly upheld and workers' voices are finally heard. Thank you very much.
Thank you very much, Mr. O'Brien. Our next panelist is Mr. Greg Leroy. He is the Executive Director of Good Jobs First, which he founded in 1998. Good Jobs First is a national policy resource center for grassroots groups and public officials promoting corporate and government accountability. Mr. Leroy, thanks a lot for being with us.
Thank you, Mr. Chairman and committee members, for the opportunity to be here. My name is Greg Leroy, and I direct Good Jobs First, a nonprofit, nonpartisan research center on economic development incentives and corporate accountability. We believe that companies which receive government economic development subsidies or procurement contracts should be held to the highest standards of corporate ethics. Government money should not keep going to any company that violates laws, rules, or regulations intended to protect workers, consumers, free markets, or the environment. Otherwise, public dollars are subsidizing corporate behavior that is at odds with the policy objectives of economic development and ethical procurement. Amazon.com is perhaps the most aggressive company in America today seeking economic development subsidies. Since 2012, when it opened its economic development office, it's been averaging almost 20 state and local subsidy awards per year for data centers, warehouses, office buildings, and its various subsidiaries. They now total almost $4.2 billion. Last year alone, Amazon pulled down 20 deals worth at least $700 million. These understate the rate of subsidization. Some of the subsidies are not fully disclosed. For example, sales, property, or utility tax exemptions granted to some of their data centers are incompletely or wholly undisclosed in some states. According to the Wall Street Journal in 2017, the top management team gave the economic development team at Amazon a goal of extracting $1 billion per year in subsidies. It's also very aggressive seeking government procurement contracts, especially for its profitable cloud computing division, Amazon Web Services. In 2013, AWS was awarded a contract by the Central Intelligence Agency worth up to $600 million over 10 years. It was later in 2020, along with 4 other companies, awarded a new cloud computing contract for the intelligence community, reportedly worth tens of billions of dollars over multiple years, and now recently the new NSA award for $10 billion for the NSA Hybrid Compute Initiative. Less well known than these high-profile federal contracts is Amazon's push into local and state procurement. It began that push in 2016 and now claims to sell to 90 of the biggest cities and counties in the United States, and 45 state governments buy at least once a month from it. It's one of the 2 fastest growing segments in the company's sales, the company wrote last year. So it's clear that public economic development and procurement dollars are deeply baked in to Amazon's business model. Given that fact, we believe that Amazon should be held to the highest ethical standards of conduct, and if it fails to meet those standards, it should be disqualified from both government contracts and development subsidies. In addition to the company's widely reported unfair labor practices that my fellow panelists have already discussed, Amazon or its subsidiaries have been penalized scores of times by federal or state regulatory agencies or as a result of private litigation on workplace issues such as wage and hour violations. 5 wage and hour cases totaling almost $82 million include a Federal Trade Commission penalty. I'm quoting the commission now saying, a final administrative consent order against Amazon which agreed to pay more than $61.7 million to settle charges that it failed to pay Amazon Flex drivers the full amount of tips they received from Amazon customers over a 2.5-year period. Amazon entities have been penalized dozens of times by the Federal Aviation Administration for air safety violations and more than 20 times by the Occupational Safety and Health Administration, or OSHA, for workplace safety violations. When a company violates workers' rights to freely organize a union, that contradicts a fundamental idea within economic development and public procurement. That idea being that public dollars should always serve to raise living standards and reduce inequality, never to suppress wages or suppress benefits and thereby exacerbate inequality. Otherwise, why would we collectively favor a company with subsidies or contracts? Why would we pay a company to make inequality worse? Corporate recidivism is a longstanding problem in the United States, and many people have observed that it continues because penalties are not stiff enough, especially personal penalties for top executives. We at Good Jobs First would submit that losing government contracts and subsidies might get the attention of a company like Amazon that is so wed to public dollars. Thank you.
Ms. Leroy, our next panelist is Ms. Rachel Gressler, who is a senior research fellow at the Institute for Economic Freedom at the Heritage Foundation. Ms. Gressler's work focuses on retirement and labor policies such as Social Security, disability insurance, pensions, and worker compensation. Ms. Gressler, thanks very much for being with us.
Chairman Sanders, Ranking Member Graham, and members of the committee, thank you for the opportunity to be here today. Regarding the question of taxpayer dollars going to companies that violate U.S. labor laws, the federal contracting process is not an appropriate or effective way to address the apparent concerns. It would do far more harm to taxpayers and strip Americans of vital services, including health care and national security, than it would to penalize the targeted companies. Moreover, a federal judge issued an injunction against a similar Obama order in 2016, and Congress already struck down individual agencies' similar blacklisting rules in 2017. A more relevant question for the Budget Committee, given the $30 trillion federal debt, reckless spending, high inflation, and an unprecedented labor shortage, is how can policymakers promote a better functioning labor market with more people working and with real incomes rising instead of falling? To that end, I'd like to briefly consider the current labor market conditions and evaluate two different labor policy approaches. Today's labor market is unlike any before in history. Massive government spending financed by the Fed's printing of money has artificially increased demand, while other government policies have discouraged work. That's contributed to a record high 11.5 million job openings. There are almost 2 jobs available for every unemployed worker. Employers are responding to the labor shortage by providing greater flexibility, expanded benefits, including a 64% increase in workers with access to paid family leave, and also higher pay. In March alone, 49% of employers reported that they increased compensation. But despite the fact that average earnings are up $3,300 over the past year, the average worker is $1,600 poorer after inflation. The problem is that when employers are forced to raise compensation without workers actually producing more, they have to raise their prices, and that adds to the inflationary cycle. Similarly, unions' use of muscle as opposed to merit-based compensation increases leads to higher prices and fewer jobs. Policies like Protecting the Right to Organize Act that prioritize union membership over workers' desires would add to inflation, fail to meet workers' needs, and ultimately lead to a smaller labor force and lower incomes. Under the PRO Act, workers could lose a lot, including their right to a secret ballot union election, the privacy of their personal information, the choice of joining a union and paying union dues, the ability to be their own boss, and the opportunity to own a franchise business. Most troubling to me, as a mother of 6 young children, is the PRO Act's attack on independent workers. 59 million Americans participated in independent or freelance work this year. During the pandemic, it was a lifeline to many, including 12% of the entire workforce that started freelancing in 2020. Independent work is growing because people want it. They report greater work-life balance, less stress, better health, and the same or higher incomes. For many people, it's independent work or no work. Half of those who freelance say they do it because they can't work for a traditional employer. Closing off opportunities for people to work in the way that they want and need may increase union dues, but it won't help workers and it won't help the economy grow. Instead of attempting to recreate the workplace of yesteryear, dominated by unions, manufacturing, and men, Congress should modernize labor laws. First, policymakers should protect flexible and autonomous work by clarifying in law that people who control their own work can be independent contractors. Congress should also protect the franchising model by codifying the long-standing precedent that franchise owners are their workers' sole employer. The Employee Rights Act includes these two important provisions, along with other important worker-first policies like privacy protections, secret ballot union elections, and the right to earn a raise. Congress could alleviate worker and union clashes by respecting both parties' rights to choose. That is, by ending forced unionization and also ending exclusive representation, so that workers aren't forced to join unions and unions aren't forced to represent workers that don't join them. Finally, policymakers should help expand lower costs and more effective education alternatives by reducing higher education subsidies and allowing things like industry-recognized apprenticeship programs that have proven effective at helping workers. The future of work requires an agile and expanding workforce, not a one-size-fits-all model. So lawmakers' goal should be to allow more people to gain the skills they need, to work in the jobs they want, to choose the employment arrangements that work best for them, and to earn rising incomes that allow them to pay for what they want and to pursue what they desire. Thank you.
Thank you. Our last panelist we will be hearing from virtually, and that is Mr. Glenn Spencer, who is the Senior Vice President of the Employment Policy Division at the U.S. Chamber of Commerce. In this role, he oversees the Chamber's work on traditional labor relations, wage hour and worker safety issues, and state labor and employment law, among other issues. Mr. Spencer, thanks very much for being with us.
Chairman Sanders, Ranking Member Graham, and members of the committee, I appreciate the opportunity to speak to you today. The U.S. Chamber of Commerce directly represents 300,000 businesses and represents approximately 3 million more through our federation partners. These businesses take seriously their obligations to follow all laws, including those involving labor and employment matters. These businesses devote considerable time, talent, and resources towards achieving compliance. The unfortunate truth, however, is that some laws are less than clear and can be extremely complex. The same applies to regulations implementing those laws. In addition, these laws and regulations sometimes overlap, and there are additional laws and regulations at the state level. Take, for example, independent contracting. There are multiple standards just at the federal level. The IRS, the Department of Labor, and the National Labor Relations Board all use different tests. In addition, there are state tests, and some states use separate tests for wage and hour, workers' compensation, and unemployment insurance. The result is a confusing patchwork of laws and regulations that can be challenging to understand. This type of complexity, which occurs across numerous areas, is why we see so much litigation around labor and employment issues. Two people can look at the same factual situation and draw two different conclusions about whether a particular workplace policy is compliant. This is why it's important not to jump to conclusions about whether a company has actually violated the law. Upon further review by agency officials or a court, allegations can be found to be without merit. All of this leads to the question of whether an additional penalty structure for contractors, up to and including debarment, is an appropriate policy. As a general matter, Congress has concluded that it is not. Statutes like the National Labor Relations Act, for example, articulate a specific penalty structure that does not include restrictions on contracting or debarment. Moreover, Congress has declined to pass numerous proposals to amend the penalties in the NLRA, including labor law reform legislation in 1978, the Employee Free Choice Act, and most recently, the Protecting the Right to Organize Act. Where Congress has affirmatively spoken on the question of contracting and additional penalties, it has rejected that concept. In 2017, Congress used the Congressional Review Act to overturn the so-called Fair Pay and Safe Workplaces regulation, which sought, in part, to require contractors to report violations of labor and employment laws to their contracting agencies, with the ultimate threat of the loss of federal contracts as a penalty. While there are undoubtedly many reasons Congress has chosen this course of action, one factor might be that while many businesses participate in federal contracting, by some estimates as many as 25% of employer, these businesses specialize in different services. Preventing a company from participating in federal contracting would limit the ability of the federal government to seek out the most efficient and effective provider of a particular service. In some cases, that service might not be available at all. For example, some national defense products are produced by just one lead supplier, an issue of particular salience as we look at our policy in the Ukraine. Administrations of both parties have often used the federal contract process to impose policies that they couldn't get through Congress. For example, the Biden administration required contractors to pay a minimum wage of $15 per hour. The Trump administration attempted to block contractors from certain types of diversity training. The Obama administration required contractors to provide paid leave. And the Bush administration required contractors to post notices about union rights. Now, without commenting on the wisdom of any of these policies, the unifying theme is that these were issues that did not receive congressional approval. The justification claimed was the authority of the Federal Property and Administrative Services Act. However, courts are starting to question the limits of that law, with cases in numerous courts of appeals. So as the committee contemplates the question of restrictions on contracting or debarment as an enhanced penalty, it should be mindful of those limits. One additional challenge confronts the idea of imposing such enhanced penalties via regulation, and that is the very CRA resolution that was passed in 2017. Under the CRA, a rule that is struck down may not be reissued in substantially the same form. This is a significant barrier. So in conclusion, Congress has enacted numerous labor and employment statutes. Each of those statutes contains specific penalty provisions. If the consensus in Congress is to change those penalty structures, Congress is free to do so. However, attempts to do so administratively are likely to run into the barrier of the CRA and may also face greater scrutiny by the courts. So again, thank you for the opportunity to speak to the committee today.
Mr. Spencer, thank you very much. Let me begin my questioning by responding briefly to Senator Graham. I think he suggested that a hearing like this is radical. And you know what? I think he's right. In a Congress dominated by corporate lobbyists and wealthy campaign contributors, the idea that we would actually hear from the working class of this country is, in fact, radical, but I make no apologies for that. Let's begin with Mr. Smalls. Mr. Smalls, if you could, describe a little bit about the pressures that exist at Amazon when workers have decided that they want to form a union.
Absolutely. Well, for one, let me just describe what the environment is. These buildings are 14 NFL football fields, 1 million square feet, some of them over 1 million square feet. Staten Island, for example, JFK 8. These workers are commuting from all 5 boroughs. So their commute could be, and New Jersey as well, could be anywhere between 2.5 to 3 hours each way, not including their 10 to 12-hour shift if they're full-time, only subjected to a 30-minute lunch period and 2 15-minute breaks. If you work 12 hours, you get 45 minutes and 2 15-minute breaks. So just think about that by itself. Just working under those conditions, as well as enduring union busting, which Amazon flies in hundreds of union busters from all over the country, pretty much all over the world. There's some that come from overseas as well. They come into the facility, they isolate workers every single day, question them, pretty much gaslighting them, acting like they are working to improve the conditions, but really they are just polling to see who's pro-union, who's not. They report that information back to management. They have captive audiences every single day. For example, at JFK 8, they did them every 20 minutes. They brought in classrooms the size of 50 to 60 workers, drilled anti-union propaganda into their heads for nearly an hour, and they did this 4 times a week. Every single day, workers come in, they go right to a captive audience. So imagine being a new hire at Amazon. Your second day, you don't even know your job assignment, and the first thing they do is march you into a anti-union propaganda class. Other examples are they post and plaster the building with anti-union propaganda. You walk in, the first thing you see is vote no. You walk in, the first thing you see is union dues coming out of your check. They calculate union dues without even knowing how a union operates. They pretty much spread rumors and lies about the union members, trying to claim that this independent worker-led union that are all Amazon workers are some third party. They lied and said that, the union dues, the money is going to go towards my financial gain. Pretty much they demonized myself as the union representative, saying that I have a vendetta because I was fired 2 years ago wrongfully. Other things that they do is use the police to intimidate the workers. There was a large presence in Bessemer. I remember when I went down there for the first campaign, they had police at every entrance. Same thing in Staten Island, they used the police at all our demonstrations. Myself and 2 other organizers were arrested, not once, but twice, and we're still sitting here as we speak on papers because of that.
Okay. Senator Graham, I'm going to take an extra 2 minutes, and I'll give you his equal amount of time. Let me ask President O'Brien, do non-union companies that pay workers low wages with no benefits and repeatedly break the law have an unfair advantage when they compete for federal contracts and subsidies with companies that obey the law and have a union contract?
The answer to that question, Mr. Chairman, is absolutely. We represent 1.2 million working people in various industries. We have a similar company under contract that has a 70-year history with the Teamsters Union that does and has a proven model of what it is to work for a unionized workforce and still remain very profitable and very successful. Those jobs are 67% at UPS part-time jobs, which provide full-time benefits, full-time health care, and full-time pension contributions. But more importantly, it provides an ends to a mean. Unlike Amazon, when you go to work and they have 150% turnover, that's criminal. When you go to work at UPS as a part-timer, you know that at some point in time, you have a means to an end for a full-time career, delivering packages and parcels. And, I think the one thing that is getting lost in this whole testimony is, we're talking, and we're all entitled to our opinions, and that's the beauty about being an American. But we do have a proven model that worked. It worked through the toughest economic times when there were no vaccinations, but people needed goods and services delivered. Our Teamster members, whether it was at UPS, whether it was in the freight division, whether it was picking up rubbish or stocking and delivering essential groceries to people, we proved our worth. We proved our value. And, Amazon workers should have that same ability, and or any workforce that is being taken advantage of or retaliated for their beliefs. Now, as far as a competitive advantage, when employers use a subcontracting or an independent contractor model, they're not paying benefits, they're not paying retirement, they may be skirting the law as far as wage and hour violations go. They have a significant competitive advantage with a service that is awful. If you go to any neighborhood right now and you talk to an Amazon subcontractor, or as I think it was referred to by one of my panelists, as a opportunity to be their own boss, that's furthest from the truth. They have to buy the vehicle, lease the vehicle from Amazon. They have to wear the uniform that Amazon says. They have to follow policies and procedure. Sounds like not being their own boss to me. Look, in any event, we need this. We need the PRO Act. We need America to do the right thing. If someone does something wrong outside of, in their neighborhood, they're held accountable. Amazon needs to be held accountable, and how you hold people accountable is taking back some of these contracts until they are a responsible employer.
Thank you very much. Senator Graham.
One way you shouldn't hold people accountable is have a hearing where you make accusations. There's a legal system. You reach conclusions, and you want a result that I think would do a lot of damage to the country. That's what's radical here is we've taken a single company. You've brought people making accusations. There's a legal system in this country to complain about unfair labor practices. But what you've done here today is you've tried and convicted Amazon. You've taken anecdotal testimony and said Amazon is the worst offender on the planet of the workplace. All I can say is that, Mr. Smalls, have you filed a complaint when you thought you were wrong?
Have I?
Yes.
The Attorney General of the state of New York has on my behalf.
Okay, but you had a process where somebody could advocate for your interest.
There is a process that's not working.
Okay, well, that's your opinion. Now,
That's a fact.
let me ask you this. Do you believe that if you're in a workplace, you should be required to join a union?
I believe that we should have the right to choose to join the union.
Okay, so you would agree with me that if you didn't want to join a union, you shouldn't be made to do so.
Who's making them do that?
The PRO Act.
The PRO Act is making them do
You have to pay
that?
union dues whether you agree to it or not.
I don't believe that's correct.
Well,
I think the PRO Act is giving
Ms.
workers the
Gessler, is that
opportunity
correct?
to do that.
Yes, that's precisely what the PRO Act does, is that as a condition of being employed at a company, you have to pay union
Yeah,
dues
so
to
this
be
is a
member.
good deal for the unions, right? Mr. O'Brien, do you support the idea that if you receive a government contract as a company, you must sign a statement of neutrality regarding unionization?
I definitely believe in that, sir.
Yeah, well, I don't.
That's your opinion?
Well,
That's
right.
great.
And let me tell you why I don't. Because that means if you're Boeing in South Carolina and you want to do business with the military, you can't give the other side of the story why unionization may hurt productivity and it's not the best way for the worker. So unionization efforts in this country have gone from 11.9% of the private sector workforce, including government employees, I think, maybe non-government employees, down to 6.1%. Maybe people are listening to what you're having to say and want to go a different way. Maybe they don't want to pay dues to a union because they work at the site that's been unionized. Maybe people are making a different choice. The number of people joining in unions in this country is going way down. Is it due to the abusive behavior of all the companies, or is it maybe people want to make an individual choice? I have an uncle who is in a paper mill union. I love him dearly. I understand the union argument and let people listen to it. I just want the employer to be able to give the other side of the story. Ms. Gessler, in your view, this idea of requiring companies to sign a neutrality agreement to do business with America, what would that lead to?
Well, I think that's actually unfair to workers. Companies are required to notify workers of things that are important to them in their workplace, and what we're doing here is preventing workers from having that right to know something that is significant for the future of their work.
This is not about righting wrongs because there's a system to do that. This is about getting an outcome you want. There was a Staten Island vote Monday where the union effort was rejected 62 to 38. If you believe this panel, the 62% of the people are crazy. They don't know what they're doing. They were intimidated. Maybe they just made a different choice. Thank you.
Thank you. Senator King.
Thank you, Mr. Chair, and thanks to all of you. Very, very interesting testimony. I said at a hearing, Mr. Chair, I think about 2 weeks ago here, that maybe I'm not fit for this line of work because I was born with a paint box that has no broad brushes in it. And so, I mean, I'll start with you, Mr. President. I don't challenge some of the facts that my chairman laid out or that you've laid out, and I think some compelling stories, but I don't think Amazon is an organized criminal syndicate.
It definitely is the way they treat their workers, sir, with all due respect.
Yeah, so I mean, I know that that's your opinion, and you are as sincere in stating that as I am in saying that I think that's a vast overstatement. Amazon employs 1 million Americans. Not everybody hates their jobs at Amazon. Tens of thousands of them work in Virginia. Not everybody hates their jobs at Amazon. Amazon's going to open a huge headquarters in Northern Virginia that was going to have 25,000 employees, but after New York said, we don't want you, it's going to be 35,000 employees in Northern Virginia, and Virginians are very excited about it. It's in probably the bluest part of Virginia, and the County Board of Supervisors, they're thrilled to have Amazon. Mr. Smalls, I agree with you. I don't care one whit about Jeff Bezos. I think the workers make Amazon go, and the customers, and the customers. And customers that use Amazon, they use it because they think it's convenient. And during the pandemic, when they were at home and they didn't want to go to some places because they were worried about their health, Amazon usage went up. We can't wave a magic wand and make customers suddenly not like Amazon. So I would say I just don't see it. All the facts that have been laid on the table are facts that I'm going to now dig into with some of the others on the panel. But I think you have to acknowledge 1 million employees and customers that find Amazon to be, somebody good they want to work with. That is at least also a fact that has to be put on the table. My view is coming from the way I come from. I come from a very pro-labor household, and I'm a PRO-ACT supporter. I'm going to talk about why. My dad was management. He ran an ironworking shop that was organized by the ironworkers. And we all grew up working with union ironworkers in my family. It was my dad and my mother and my 2 brothers and me. And in a good year, 5 employees, and in a great year, 7 employees. And my dad was on the Ironworker Pension Fund as the management representative. And he just taught us growing up, unions and management shouldn't be fighting. It should be a team. And I hope that's what I hope we're kind of shooting, that we would want to be a team without owners kicking workers around and without employers being demonized. I mean, Democrats, if we want to love jobs, we got to also work with those that are building companies that create jobs. Now I want to get over on why I'm a PRO-ACT supporter, because I think, Ms. Gensler, I think you said a couple of things that I don't think are true. You said the PRO-ACT gets rid of the secret ballot. No, it doesn't. It strengthens secret ballot. There were earlier bills in Congress that got rid of secret ballot, like the EFCA. But what the PRO-ACT does is it requires a secret ballot if the employer wants it. If the employer doesn't want to accept cards of more than 50%, the employer can require a secret ballot. And there will be a secret ballot. Unless the employer conducts such unfair labor practices during the election, then the NLRB can order that showing of a majority of the workforce wants a union will go into effect. I think that solidifies secret ballot. The other thing the PRO-ACT does on secret ballot is this. Under current law, employers can decertify a union without a ballot. If they feel like they have evidence that there's no longer majority support, an employer can decertify a union. The PRO-ACT says you cannot decertify a union without a secret ballot. So I've heard you and others come up here and say, oh, the PRO-ACT gets rid of secret ballot. I think that's just a flat-out misstatement. I've heard it made over and over again. It doesn't. It actually strengthens secret ballot. Mr. Small said he thinks people should have the choice about a union. You should have the choice to vote for a union or not. And if a majority votes for the union, the law has been for decades that the union then has to represent the entire bargaining unit. The PRO-ACT doesn't require that you join the union if there's been a successful election. It does require that you make some payment to the union for that representation so that you're not a free rider. If the union is obligated to bargain for somebody whether they join the union or not, get them benefits, get them health care, get them pensions, why should they be able to get that for free? Again, if we're going to respect the democracy of a vote for a union, then you're going to get some benefit from it. What's your right to just be like a free rider on that? The other thing about the PRO-ACT that really convinced me, Mr. Chair, and this goes to Mr. Small's testimony about them waiting you out. We have a National Labor Relations Act that says, okay, you got to have a campaign and have an election. So if the union wins the election, shouldn't there be a contract? I mean, it would seem if the union wins the election, shouldn't there be a contract? Well, the average number of days it takes after the union wins an election, and they don't always win, but after the union wins an election, the average number of days to get to a contract is 409 days. And about a third of victorious unions can't get a contract in the first 3 years because the employer just stonewalls. So what the PRO Act does is it requires that after a successful union election, after there's been a democratic determination by the workers that they want a union, that you have to reduce it to a contract within a certain period of time, and if you don't, it goes to arbitration. That seems completely fair to me. Otherwise, you're not respecting the democratic desire of workers for a union. So the chairman did a nice thing. He came down to Virginia to celebrate 5 Richmond Starbucks that recently unionized. I was out with the Starbucks employees during that time. And another one, Mr. Chair, in Farmville, Virginia, just unionized a couple of days ago. And I strongly supported their right. If you want a union, I'm not telling you what you should want, but if you want a union, you should have it. And once they voted to have a union, they should be entitled to have it and get a contract within a reasonable period of time. I just hope, we can, I don't know, maybe I'm naive thinking that the world can work the way it did in my dad's ironworking shop. And that if workers vote for a union, that they wouldn't be kicked around, they wouldn't be harassed, they wouldn't be fired, they wouldn't be stonewalled, but we get to the business of creating a working relationship that's a productive one for everyone. The last thing I'll say, Mr. Chair's heard me say this before. My dad used to always tell us, listen, my business acumen is going to put all my workers' kids into career programs, union programs, or colleges. But you boys, my brothers and me, you guys need to remember that the artistry of these iron workers is going to put all you guys through college. I just hope we might have an economy that people view themselves as on the same team. Thank you, Mr. Chair.
Senator Kane, thank you. Senator Brunn.
Thank you, Mr. Chairman. Senator Kane, I don't think you're naive. I think that I came here today knowing that there wouldn't be many of us here, number one. Coming from Main Street, where 37 years prior to becoming a senator, I ran a business. And you don't have high turnover if you have high wages. You don't have accidents at your business that are way out of norm if you run it like your own family is working there. If you're conscientious for your employees, it's kind of a moot point. And sooner or later, it works itself out. I had 15 employees for 17 years. Lucky, finally, that it scaled into a larger business. Lived with low overhead, hard scrabble. All along the way, and I mentioned it about 8-9 years ago when I was awarded an entrepreneur's recognition, and mentioned at that get-together that high wages and good benefits should be the hallmark of running a business, growing it, and return on investment. I saw some kind of reaction out in the crowd, which would have been mostly Chamber of Commerce, other entrepreneurs. But if you do it, a union is probably not going to be necessary, but when you look at concentration in industries, you look at Amazon itself, they've actually created a new mousetrap that'll have its own reconciliation in terms of where that can be scalable. It's not going to be scalable ultimately if you have 150% turnover rates or if you have accident rates way above the norm. So do we resolve it here? Do we put regulations in place? Sometimes you've got to. But I do believe the system in the long run will take care of itself. And when you've got big concentration in industries, you're going to get folks like me from the entrepreneurial business side that don't like it. Most of us don't have lobbyists. Most of us don't business partner with the federal government like large companies do. So you got to be careful that you don't stereotype, I think, what's made this country great, which would be mostly Main Street entrepreneurs, many small businesses where they're as blue-collar as a blue-collar job would be working for a larger company because they make their earnings out of those businesses. So when you get situations where it's egregious, sooner or later you'll be held accountable. Standard Oil did, the telephone business did, I've been railing along with the chair here about the healthcare industry. It costs too much. Everybody in this day and age ought to be entitled to health care that you've got access to, whether it's provided by an employee, some have to turn to government, that doesn't cost you twice as much in some cases as what it does in other countries. That's why you have hearings like this. All of this has to blend together, doesn't necessarily have to be mandated by government, but when somebody does get out of line, when wealth gets too concentrated, when you've got 150% turnover rates, high accident rates, you're going to have a medium to vent your grievances. And unions, vis-a-vis large companies, probably the only way you can do it. I've always been a believer that you can organize, but you can never let something get out of hand to where it gets too far the other direction, and never lose sight of what's made the country great. It's been based upon hard-working individuals. The town I come from is blue-collar, entrepreneurs. We all play together, we work together, and we get along together. And when you pay the highest starting wages, basically, in the lowest unemployment areas, your business prospers, and your employees do along with you. I've always had a beef, too, owning a business. CEO pay of 150 times the average worker. That's not going to work. You know, I never did it in my own business. I would have been embarrassed to do it. On the other hand, you want to make sure you don't squash innovation, entrepreneurialism, because that's what makes our country great. And that's got to walk alongside workers benefiting along the way. That's my 2 cents. That's why I came today. Thank you.
Thank you, Senator Brunn. Senator Van Hollen is with us virtually.
Thank you, Mr. Chairman, and let me thank all of our witnesses today. Mr. Smalls, you mentioned in your testimony that in addition to firing you, Amazon also fired Gerald Bryson, who was one of the other protest leaders. Amazon claimed that Mr. Bryson was fired for statements he made in an argument with a coworker, but here's how an NLRB administrative judge described Amazon's review of Mr. Bryson's conduct that led to his illegal firing. And I'm quoting now from the judge. An ostrich-like head-in-the-ground investigation that seeks to avoid evidence which might disclose information mitigating the employee's misconduct, unquote. In other words, Amazon deliberately ignored the facts, deliberately misrepresented the situation, and that's why the NLRB ordered Amazon to reinstate Mr. Bryson with back pay and found that his termination had been wrongful. So, Mr. Smalls, you know Mr. Bryson. Why do you believe, why did Amazon fire Mr. Bryson?
A few things. Number one, he's black. Number two, he was protesting alongside with myself and others over COVID-19, which was running rampant at the time. New York was the epicenter. So they wanted to, once again, silence the organizers that were advocating for that, myself included. You know, I'm still unemployed as we speak.
And when a company like Amazon takes that kind of action in retaliation for a protest, does that make it more difficult for you to organize?
Of course it does. It's an intimidation factor. You know, if they fire the people that are speaking up, everybody else wouldn't want to come forward because they think it's going to happen to them.
Yeah. So, you know, and here's the thing about our system. It took 2 years or a little longer than 2 years for this particular case to wind its way through the NLRB and get a decision from an NLRB judge. And, you know, by that time, the damage is already done, not just to the person wrongfully fired, but also to the organizing effort. We've just got to dramatically improve this system, and that's why we want to provide additional resources to the NLRB and make other reforms. I chaired a hearing just earlier this week in the Appropriations Committee. I chair a subcommittee called the Financial Services and General Government Subcommittee. And I discussed with the IRS Commissioner the fact that we already debar, we already prevent federal contractors who don't pay their taxes from getting government contracts, right? It makes sense that if you're not paying your taxes on time, you shouldn't benefit from a contract where the taxpayers are funding it. We also will hear later from a GAO witness on the second panel that federal contractors can also be debarred for violations of the Service Contract Act. And the existing federal acquisition regulations provide for debarring federal contractors for any offense indicating a lack of business integrity or honesty. Mr. Leroy, given that we already have these provisions in place for violating tax laws, service contract laws, and other circumstances, why wouldn't we also say that for contractors who are engaged in serious violations of labor law, that they would be prohibited from getting federal contracts, at least for some period of time?
I wholly agree, Senator, and I'm proud to say that I'm a Maryland resident, and that you represent us very well. Looking at the debarment criteria for some of the General Services Administration, even state governments, they all have procedures. We're simply saying we want to elevate labor law to the same magnitude and significance as tax law or integrity law or antitrust law, and I think that's a very reasonable thing to do. It's saying we care about workers, and we're not going to pay companies to degrade workplaces, suppress wages, make inequality worse.
And just in my closing seconds here, Mr. Spencer, and do you disagree? Should we have a carve out? In other words, and I'm talking here where we would agree that there's been a significant violation of labor law, right? Would you agree that that is the kind of violation that, at least for a period of time, should disqualify a contractor from getting a taxpayer-funded contract?
Well, what I would say is I think I agree with your point that there is a procedure in place currently under the federal acquisition regulations to determine whether a contractor is suitable to receive a contract. I used to work in the federal government, so I knew contracting officers when I was there. I still know some of them now, and I trust those folks to use their best judgment when evaluating a contract as to the suitability of an individual contractor. I just point out one thing here, not to talk about Amazon, but one of the things that they did during the pandemic, as we recall, there was a dramatic expansion in the unemployment insurance system to provide benefits to people who are out of work. AWS helped some of the states deal with the computer upgrades that needed to happen to make sure that those benefits could be paid on time and to people who had earned those benefits. So if you're limiting the ability of companies like that to provide those vital services, that's going to inhibit the ability of people to collect the benefits that they've earned. So I would say that I think contracting officers can make those evaluations and can use their balanced judgment to determine whether somebody a company is suitable to receive a contract.
Right. We shouldn't have a situation where gross violations of labor rights are actually treated differently than gross violations of other law that bar people from getting contracts. I see I'm over my time. Thank you all. Thank you, Mr. Chairman.
Well, thank you, Senator Van Hollen. And with that, let me thank all of our panelists for your presentations. I found them very interesting. Thank you all very much.
Thank you.
And now we're going to hear from Tom Coster with the GAO. Mr. Costa, thanks very much for being with us. Tom Costa is the Director of the Education, Workforce, and Income Security Team at the U.S. Government Accountability Office. Mr. Costa oversees GAO's work on worker protection, safety, employment, and training issues. He has worked at the GAO since 2005. Mr. Costa, thanks for being with us.
Thank you for having me, Senator. Chairman Sanders, members of the committee, thank you for inviting me to testify about enforcement of the Service Contract Act, or SCA. The SCA was enacted to provide labor protections for federal service contractor employees such as administrative staff, janitors, security guards, and mail haulers. Contracting agencies such as DoD or the Postal Service are responsible for administering the SCA while DOL enforces the law. Under the SCA, workers do not have a private right of action against employers. However, DOL can withhold funds from contractors found to have violated the SCA to ensure that workers are paid what they're owed. My written testimony summarizes the information we reported in our 2020 report, including what available data revealed about past SCA cases, challenges the DOL faced in enforcing the SCA, and challenges contracting agencies faced in implementing it. Let me start with a high-level overview of what we found. DOL's Wage and Hour Division conducts investigations in response to complaints on its own initiative or on its own initiative, carrying out more than 5,000 investigations from fiscal year 2014 through 2019. Just over half of these cases involve DoD, the largest federal contractor, or the Postal Service. DOL found violations in 68% of these completed cases, most of which involved fringe benefits or wage violations. In 94% of the cases with violations, employers complied with DOL. And from fiscal year 2014 through 2019, employers agreed to pay back approximately $224 million in back wages. DOL also debarred 60 employers during that same time period, which prevented those employers from being awarded new contracts for 3 years. I will focus the remainder of my statement on the updates we received from both DOL and the Postal Service in response to our 6 recommendations. First, while DOL tracks SCA information in an enforcement database, we found inconsistent data entry on federal agencies hindered its efforts to use the data for enforcement purposes. For example, the Postal Service had over 35 different namings in the database, and I'm pleased to say that DOL has closed this recommendation by updating its database. Second, we found that DOL lacked a complete picture of the effectiveness of its enforcement efforts because it did not analyze the information on its use of enforcement tools such as compliance agreements or debarments. Without analyzing this information, DOL may not know how best to utilize its resources in resolving SCA cases. In response, DOL has revised its tracking system and plans to issue a summary report at the end of each year. However, while this is a positive first step, DOL has not indicated how it will analyze that information to see how effective their efforts are. For our 3rd and 4th recommendations, we found communication gaps between the Postal Service and DOL. The Postal Service has the 2nd largest number of SCA cases of any agency and the largest number of debarments of any agency. We recommended that the DOL and the Postal Service develop written protocols to improve their communication. Both agencies agreed and have started working on a memorandum of understanding. However, after some back and forth, we heard from both agencies that they're waiting for the other to proceed forward, indicating that the communication gap still exists. 5th, we found that contracting agencies such as DoD and the Postal Service may have incomplete information about SCA violations from DOL, which could affect their ability to make fully informed decisions when awarding new contracts. For example, the contracting agencies might not know that a contractor had been debarred, and this could increase the chance that a debarred contractor could get a contract it shouldn't. We recommended that DOL take steps to ensure that the unique contractor identifier be included in debarment records. According to DOL, it has developed a tool to link these numbers to both contracting and performance records. However, the government transitioned this past month to using a new unique identifier, and we are not sure yet if DOL has adjusted its processes to accommodate the new system. Finally, we found that DOL did not always communicate enforcement findings in a way that was readily accessible to contracting agencies. Information on past violations may assist contracting agencies to determine whether a prospective contractor has a satisfactory performance record. We recommended that DOL develop written procedures for relaying SCA findings to the contracting agencies, and DOL indicated it's in the process of doing so. I am pleased that DOL and the Postal Service have taken our recommendations seriously and begun taking action. Nevertheless, more needs to be done, and we will continue to monitor both agencies' efforts. This completes my prepared statement. I'd be happy to answer any questions.
Well, thank you very much, Mr. Costa. Let me begin by asking you, are companies with past labor law violations still getting government contracts? Why is the Department of Labor not using its debarment authority to prevent this?
Yes, contractors who do get debarred are still getting contracts. We identified 622 contractors that had SCA violations that received subsequent federal contracts worth $35 billion. It's important to note that the SCA, unlike some other labor laws, doesn't grade on the scale of severity, so an honest mistake is treated the same as a willful violation. That said, DOL did identify 379 cases where there were previous SCA violations or other violations, and the contractor still got additional contracts. In 19 of those cases, those contractors were subsequently debarred.
Give us some examples of serious violations of the law in companies that still have government contracts.
We looked at aggregate data, sir. We didn't look at specific contractors, so I don't know exactly. Under the SCA, it would be wage violations, so it would be misclassifying someone as a much lower paying position, or it could be denying people their fringe benefits like paid leave, vacation time, health benefits, things like that.
And how widespread is that?
As I noted, there was not too much of abuse there. There was, well, I should take that back. There were over 5,000 cases. DOL found violations in 68% of those cases. So there was
It seems to be pretty widespread.
I'm sorry. It was pretty widespread. What we don't know is the severity of those cases. We know that only 60 were debarred.
What portion of SCA violations included violations of other acts, such as the Fair Labor Standards Act?
Yeah, so as at least 379 cases included either prior violations of the SCA or violations of other acts like the Fair Labor Standards Act or the Occupational Safety and Health Act.
Well, let me just thank you for being here and thank you for the work you are doing. I think that taxpayers in this country want to know that when their tax dollars are going to contracts with companies, that those companies obey the law. I don't think that's asking terribly much. Do you agree?
Companies should obey the law. That is correct, sir.
All right. So I think we're making progress, but we still have a very long way to go. And with that, Mr. Costa, thanks so much for being with us.
Thank you, sir.
As information for all senators, questions for the record are due by 12 noon tomorrow, with signed hand copies delivered to the committee clerk in Dirksen 624. Email copies will also be accepted. Under our rules, the witnesses will have 7 days from receipt of our questions to respond with answers. With no further business before the committee, this hearing is adjourned.